Good afternoon, ladies and gentlemen. I saw quite a few friends on the list, and thank you for joining this event. I hope we could open the campus and have more face-to-face events in the near future. So welcome to the Roundtable on Overseas Non-Permanent Judges in the Hong Kong Court of Final Appeal. This event is organized by the Center of Comparative and Public Law, CCPL. My name is Fu Hualing. I'm the Dean of the Faculty of Law. Laureate and Hodge resigned from CFA as non-permanent judge, and their resignation has caused some concerns and triggered some emotional responses. Article 82 of the Basic Law authorizes the Court of Final Appeal to appoint foreign judges when needed. It reads, the power of final adjudication of the Hong Kong Special Administrative Region shall be vested in the Court of Final Appeal of the region, which may, as required, invite judges from other common law jurisdictions to sit on the Court of Final Appeal. For someone to reading this article, immediately three questions come to mind. Firstly, since May in Article 82 emphasizes the discretionary element, do we need foreign judges? In practice, of course, the answer would seem straightforward, for we have invariably invited foreign judges every year for the past 25 years. Foreign judges on CFA and at other levels have made invaluable contributions to Hong Kong. At least we have a consensus on this point. Second, the next question that arises from Article 82 is, what is the ultimate purpose of inviting foreign judges? It seems to me that there are two possible answers to the question. Number one, to borrow a Chinese phrase, 雪中送炭, that is, they are the firewood or the charcoals in our snowy winter. Hong Kong has depended on foreign judicial assistance to maintain and nourish the quality of the judiciary. As such, foreign justice sitting on the CFA have played an indispensable role in safeguarding the rule of law in Hong Kong. Number two, the second possible answer is to this second question, to borrow another Chinese phrases, is that of foreign judges fulfill the function of 锦上添花. In other words, they are really the icing on a delicious cake. In this way, they are not indispensable, but serve as a significant function in spicing up the local judiciary and enhancing the prestige. The third and the final question is arguably the most challenging of all, namely, what options are left for Hong Kong to sustain its much cherished judicial independence in this new circumstances. As we ponder the various questions raised by Article 82, perhaps now is the good time to attempt to provide a preliminary progress report on judicial localization as we assess the prospects going forward. In light of the recent political events, if we decide that there is still a demand for foreign judges, yet there is a problem as regards their supply, then going beyond the traditional countries sourcing common law judicial talent, can we look elsewhere? And if so, where exactly? Alternatively, if the circumstances are such that the institution of foreign judges is too fraught politically and cannot be sustained in the long run, perhaps the time has arrived to consider the beginning of a new chapter in the Chinese judicial history. To help us understand the past and the future foreign judges, we are delighted to invite a panel of 5 experts and practitioners to discuss this and many other issues over the course of next 2 hours. The roundtable will take place in 3 phases. Phase 1, each speaker will make a brief presentation on an aspect of the matters for not more than 10 minutes. Second phase, following that, we will have a dialogue or conversation between the speakers. For this segment, we should have now about 20 minutes to enable the experts to clarify their positions and exchange their views. Finally, in phase 3, we'll open up the Q&A. So please type your questions at the Q&A box. We will raise the questions to our speakers on your behalf. And our speakers have access to the questions, are free to answer any questions that you prefer to answer. So without further ado, I invite the first speaker, Mr. Victor Dawes SC, the chairman of Hong Kong Bar Association. Victor, you have the floor.
Thank you, Dean. I'm going to focus on 3 issues. First of all, the resignation of the 2 judges and its immediate and ripple effect. Secondly, I'm going to talk about the update and localization of the judiciary in Hong Kong. Third, I will tackle the issue of the possibility of inviting judges from other common law jurisdictions. Can I start off by saying what is perhaps not controversial? The MPJs plays an important symbolic role. Their presence sends a message to the local and international community that all is well with Hong Kong in terms of rule of law and judicial independence. However, it is important to emphasize that the rule of law and judicial independence in Hong Kong do not actually depend on the participation of the overseas MPJs. In other words, whilst their presence on the CFA is a testament to our judicial independence or rule of law, it does not follow that their resignation would indicate that there is something amiss about Hong Kong's judicial independence or rule of law. This is because MPJs may resign or refuse to continue to serve for a wide variety of reasons, many of which may have little or nothing to do with the state of Hong Kong's rule of law or judicial independence. The recent resignations of Lord Reid and Lord Hodge are a case on point. It is clear that they resigned due to concerns about the appearance of the Supreme Court rather than because of any concerns to do with our courts. This is made clear by Lord Reid's statement, which highlights our court's commitment to the rule of law. Other examples that I can think of include Lord Millett and Lord Walker. Both of them stopped coming to Hong Kong due to health reasons. Lady Hale explained that when she resigned, she was unable to travel to Hong Kong for a foreseeable period of time in the future, and that is why she stopped. Now, in this sense, I would say that MPJs are not exactly canaries in a coal mine. Now, this is an analogy used by Lord Neuberger when he gave one of his speeches, I believe actually took place in Hong Kong News some time ago. The same analogy was picked up by Mr. Justice Robert Tang when he resigned from the Court of Final Appeal. And he said this: Lord Neuberger has likened overseas MPJs to canaries in coal mines. I agree. However, I might add that canaries can warm, but cannot save the miners. He went on to say this. He said, I believe the independence of the judiciary and maintenance of the rule of law must depend on local judges. The buck must stop at us. Serving judges, if I may say, are in a materially different position as compared to retired judges who do not take into account matters concerning UK judiciary and do not need to toe the UK government line. And that is why it is encouraging to see other MPJs, especially the 5 from the UK who made the statement shortly before the resignation of the two that they have decided to stay and they continue to support the Hong Kong judiciary. Now, next, I want to update everyone on the situation on localization in Hong Kong. The localization of the Hong Kong judiciary is, of course, a welcome development insofar as it reflects Hong Kong's success in breeding good lawyers and the growing strength of the Hong Kong bar, from which the majority of our judges are drawn. Now, no doubt, the Hong Kong judges are of very good quality. Our judges at all levels of courts enjoy a reputation of being fair and independent. And our top judges are brilliant jurists in their own right. And this is evident by the many important judgments written by them that has actually been cited across the other common law jurisdiction. However, localization should not be taken to suggest the phasing out of overseas MPJ. Hong Kong is very fortunate to have leading jurists from the UK, Australia, and Canada to serve as our MPJs. Their combination is not purely symbolic, I would say. Being renowned experts in different areas of law, they also bring something to the table when hearing substantive appeals. And their contribution is huge to the development of our local jurisprudence under Hong Kong common law. We can think of a number of examples. The one that I like using are, for example, the libel case concerning Paul Tse and Zhang Ginghorn. Lord Nichols' judgments have been cited in many different jurisdictions. Likewise, for commercial lawyers like myself, the judgment of Lord Millett in Libertarian has also been one that is cited in many different jurisdictions. Now, it is important that this work continues as it promotes cross-fertilization between common law jurisdictions, not only for benefit of Hong Kong, but also for the common law world more generally. This is also a reason why we have a practice of allowing eminent overseas counsel in appearing in our court of final appeal. Cross-fertilization is usually the biggest argument. Now, in this regard, I must say, it is of course difficult to say for sure, but the CFA's recent tendency to produce single judgment for cases, increasingly unattributed, may potentially hinder the export of Hong Kong's domestic jurisprudence, meaning that the MPJ's work is less visible, less likely to be cited in their home courts. That is something that we can perhaps watch. Now, a lot has also been said recently about the possibility of inviting judges from other common law jurisdictions. And jurisdictions such as Singapore, Malaysia, or even India have been mentioned. I believe it is wrong to assume that judges from common law jurisdictions that Hong Kong is not familiar with are unable to add anything to our jurisprudence. I think that view is probably too arrogant. The only criteria, I believe, is that they have to be top jurists. As we know, because of historic reasons, the more well-known and top jurists tend to be from the traditional common law jurisdictions with a larger pool of talents, UK, Australia, and Canada. But of course, our position is that it doesn't have to stop there. And if we can identify someone with the right caliber, we should certainly consider that. I believe my 10 minutes is not quite up, but that is all I want to say at this point. Thank you, Professor Fu.
Thank you. You saved us lots of time. I think we'll probably have more questions for you in due course. So the second speaker is Dr. Anna Dziedzic. Anna used to be working here at Hong Kong U, and now she's with Melbourne Law School. She probably is the person with most of the knowledge on foreign judges. She wrote a PhD thesis on foreign judges, and now is working on another book with Simon, also on foreign judges. So the floor is yours, Anna.
Wonderful. Thank you so much, Professor Hualing, and thank you to the law faculty for inviting me to be part of this panel discussion. As Hualing said, I've done a lot of thinking about foreign judges in a lot of different contexts across the world. And so for this discussion, I've been asked to comment on the international dimensions of foreign judging, and in particular, what happens when foreign judges on domestic courts resign. So Hong Kong is not the only jurisdiction in the world to use foreign judges, and it's not the only place in which foreign judges have resigned for personal reasons and for political reasons as well. In this presentation, I want to unpack how the resignation of a foreign judge is significant and different to that of a local judge by drawing on recent events in Hong Kong, but also global comparative experience. So in 2020, after the national security law came into effect, there was quite a bit of speculation, you might remember, within Hong Kong and outside of Hong Kong on how the foreign judges on the Court of Final Appeal might react. Notably, there was less speculation about how local judges might respond. The pressure seemed to be put onto the foreign judges. But media reports in Australia, in Canada, and the United Kingdom drew attention to the fact, and I quote, "Our judges sitting on the Hong Kong Court of Final Appeal might soon face questions about whether they should continue to serve." So resignation in protest from judicial office is generally acknowledged to be a matter of conscience for the individual judge. And as such, individual judges may, and often do, reach different conclusions about whether resignation is the best response to a particular situation. So on one hand, a judge might think that there is a degree of interference in judicial independence, there's a denigration of the rule of law, there's a break in the constitutional order, which means that they can no longer maintain their judicial oath to uphold the law and administer justice. On the other hand, a judge might think that their presence on the court can mitigate the worst effects of an objectionable law, or that despite unfavourable political conditions, they might think that they're in a position to uphold the rule of law and ensure access to justice anyway. So in all of these contexts around the world, a judge's resignation, even if it's not intended to be, is often read as a statement of concern. And this could be a statement in relation to all kinds of different things. So it could be about the conduct of political actors. So for example, in Swaziland in 2002, 6 foreign judges resigned from the bench after the Prime Minister simply refused to obey the court's orders and accused the judges of being influenced by outside forces. The concern might relate to a change of leadership or regime. So for example, in Fiji, after a military coup in 2006, 6 foreign judges resigned from the courts in that country. And they were really citing concerns about how the courts were being run under the interim military government. Finally, resignation might be regarded as a statement of concern about features of the legal system as it operates in the broader social context. So for example, some South African judges resigned or refused to accept appointment to serve as judges in South Africa under apartheid. So concerns of these kinds might arise for foreign and local judges alike. There's not really a difference in how each category of judge might consider their situation in these conditions. And in this presentation, I don't want to go into what are good reasons for resignation or try to look inside the minds of individual judges who have to make this difficult decision. Rather, I want to focus on how a judge's resignation is interpreted by those around them. And I want to suggest that foreign judges are in a different position to local judges and face different pressures and must weigh different considerations when contemplating resignation. The key difference, I think, derives from the sense that foreign judges represent dual constituencies and speak to 2 audiences, one in their home state and another in the state in which they serve as judges. So a foreign judge has an internal audience in the jurisdiction in which they're sitting, and to this audience, resignation can be given a certain meaning, but the foreign judge also has an external or international audience, first in their home country, but potentially also beyond it, and resignation might speak differently to that audience. In addition to this distinction between local and foreign judges, there's another distinction to be made between foreign judges who are serving judges in their home country and foreign judges who are retired judges. And we've seen this distinction play out in Hong Kong. So Lord Reid and Lord Hodge, who are current members of the UK Supreme Court, in fact, they're the president and the deputy president of that court, both resigned their positions on the CFA. To date, only 2 of the retired foreign judges have resigned, Justice Spiegelman and Justice Hale. And the remaining foreign judges, all of whom are retired, have said that for now, they intend to remain in their positions. So why is the situation of sitting foreign judges different to retired foreign judges? I don't think it's so much an issue of government interference or that kind of concern that I think some have suggested. One way to think it through is using the common law idea of incompatible functions. So there are some things that serving judges cannot do. So they can't exercise certain non-judicial powers, for example, because to do so would kind of taint or undermine the institutional integrity of the judiciary. A serving judge sitting in their home jurisdiction is generally able to reconcile holding judicial office in another jurisdiction because the judicial function is kind of the same everywhere and the protections on judicial independence are understood to apply across national borders. But it's possible to imagine a case, and I'm not suggesting that Hong Kong is such a case, in which judicial office in a foreign jurisdiction was so kind of degraded as to be incompatible with holding judicial office in the judge's home jurisdiction. So a serving judge has to deal with that concern, whereas a retired judge doesn't. So what we see in Lord Reid's comments this past week is that his overriding concern is for the position of the UK Supreme Court and the values that it and its judges represent. So to quote from Lord Reid's evidence to the House of Lords Constitution Committee earlier this week, he said, and I'm quoting now, I felt the time had come when we had to call it a day in the interests of the values that we represent. Because I am the president of the Supreme Court, my primary concern had to be the reputation of the Supreme Court and that institution behaving as it ought to in our constitution. I'd formed the view that it was no longer in the interests of the Supreme Court. In fact, it was damaging the interests of the Supreme Court and the respect in which it is held for us to continue, end of quote. We see here the idea of representation coming to the fore, this idea that judges represent certain values and that they represent the institution, but also this idea of reputation and concerns about the continued service of foreign judges in Hong Kong, expressed by others, not by the judges themselves always, are most often framed as an issue of reputation. But the question then is, whose reputation are we to be concerned about? So sometimes, as we see in the case of Lord Reid and Lord Hodge, the concern is for the reputation of the foreign judge's home court. Other times, the concern might be for the reputation of the individual judge. And I think that in some of the commentary about their continued presence, we see this in relation to Justice McLaughlin and Justice Hale in particular, where calls for them to resign tended to be framed around the idea that their continued service would tarnish their personal legacy. I think this is a consequence, however unfair, of the kind of judicial celebrity of those two judges. Sometimes, however, the reputation is that of the judge's home state and its government. And I want to end by unpacking this idea in a little bit more detail. So in 2019, the UK House of Commons Foreign Affairs Committee published a report entitled A Cautious Embrace, Defending Democracy in an Age of Autocracies. So the report expressed concerns about the political situation in Hong Kong as street protesters and all of that police response escalated. And the committee made the following statement, and I'm going to quote again. As one of the judiciaries represented in the Hong Kong Court of Final Appeal, we believe that there could be a reputational risk to the UK if the government inadvertently appears complicit in supporting and participating in a system that is undermining the rule of law. The committee, end of quote, sorry, the committee made it clear that its concern was in relation to retired foreign judges as well as serving judges, because it noted that it had written to its counterparts in Australia, in Canada, and New Zealand, who they say are also represented on the CFA, to urge those governments to assess the impact of continued participation in the CFA. So the committee's remarks here suggest an understanding of foreign judges as representing the state, and that the presence of foreign judges could directly reflect upon the UK government. This conception of the foreign judge, almost like a diplomat, is really, really controversial, I think. Putting aside the different position of the two serving UK judges, the UK is not represented on the Hong Kong judiciary. Foreign judges serving in Hong Kong are appointed by Hong Kong authorities. They take their oath as Hong Kong judges. They're Hong Kong judges. A further question kind of arises as to how the governments of Australia or Canada or the UK could enforce a decision to withdraw their judges from Hong Kong, and how that could be in any way compatible with judicial independence. So although it's problematic for these reasons, it's perhaps inevitable that foreign judges will be perceived as representing their home country, at least in this informal sense. Whether they like it or not, I think foreign judges are called upon to balance the demands of different actors within the two constituencies in Hong Kong and in their home state, each of which might be internally divided on this issue, and each of which might have very different understandings of the judge's role when serving in Hong Kong. And I'll leave it there. Thank you very much.
Thank you very much, Anna. So now we move to third speaker, Mr. Alan Hu SC, Chairman of Basic Law Institute. Alan, you have the floor.
Thank you very much, Dean. Can I bring my perspective to this issue, which, can I say right at the beginning, I'm very concerned about the international narrative on Hong Kong, where there are 7 million people who are still living here and functioning in a financial center in the world. When you have something like this happening, the first thing you look at is that how does it impact on the society in Hong Kong? How does it affect what we are going through now in Hong Kong? I'm a witness to the whole arrangement coming into being. This is in 1982, two events happened which are important to Hong Kong. One is the amendment to the Chinese Constitution, which allows the establishment of an SAR that will practice a different system from the rest of the country. And at that time, we were all quite aware that this was targeting the unification of China with Taiwan in mind, and of course, Hong Kong and Macau. But as it turned out, after the Falklands victory by the British government, Margaret Thatcher went to see Deng Xiaoping in 1982 and basically asked whether the lease could be extended. And when it was made in no uncertain terms, it wouldn't. And that on 1997, China will resume exercise of sovereignty over Hong Kong. And then it became a very sort of mad dash to get the thing done, right? In 1984, September, came out the Joint Declaration. And the Joint Declaration itself basically says one key thing, which is that Hong Kong will have a high degree of autonomy. And there are, in the Annex 1, the basic policies that basically breaks down how Hong Kong functions in different systems and how it can be defined. But the most important feature, there was nothing about a bargaining for democratic values in Hong Kong by the British government, that, for example, we want a chief executive to be elected by universal suffrage. That wasn't asked. What came out was just that the chief executive could be returned by elections or simply consultations. As far as the Legislative Council was concerned, a lot of the fight came afterwards in the drafting of the basic law. There wasn't anything that guaranteed universal suffrage in the legislature. But it was, curiously, in the judicial aspect that we saw a very important concession by the Chinese government, in the sense that what we're talking about is the right of final adjudication in Hong Kong. We never had that, right? We are just, after 1842 and 1997, we are just a colony in the British Empire, and the right of final adjudication lies in the Privy Council. And the argument then was, well, you must remember, in 1984, the chairman of the bar was Henry Lytton, who is very concerned, as even now is, with what's happening in Hong Kong and the constitutional aspects of one country, two system. He was the chairman. Before him was Martin Lee. And I came on board in 1985 with Dennis Chang on his committee. And in Henry Lytton's days, this was exactly what was happening in terms of the Hong Kong legal community voicing out that the right to final adjudication should remain in Hong Kong. Because at that time, one school of thought, especially from the colonial government, was how about the Singapore idea, which is to have the Privy Council retained, even after resumption of sovereignty as the court of final adjudication. And that was the Singapore model. But that was not acceptable to the central government because of sovereignty, right? Hong Kong doesn't have sovereignty. The central government has sovereignty. So then the next thing was then it went the other way, the Beijing model. Well, what about the court in Beijing? Right? Something associated with the highest people's court. No, that was immediately rejected. The local legal community did not want even to discuss that. So what did we discuss? Something which we actually were participating, the Brunei model. What is the Brunei model? Well, a lot of the Hong Kong judges sit in all levels of courts in Brunei, and the Privy Council is also the final court of appeal for Brunei. Right? So what about the Brunei model, which is that, well, if the mountain can't go to Mohammed, let Mohammed come to the mountain. Right? Have foreign judges come here. So surprisingly, at that time, the predecessor to the liaison office, the New China News Agency, had a legal director who was very, very keen on the preservation of the common law being a key foundation of Hong Kong being an international financial center. And remember, we were talking about 1982, 83. China wasn't a huge economic powerhouse then. All right, Shenzhen was just starting. Hong Kong was the plug for China in its open door policy to plug into Western economy. Right? That's why one country, two systems. So therefore, Deng Xiaoping accepted that the cornerstone of this Western economy success in Hong Kong is its common law, rule of law that inspires confidence in the West. We have the same system. We have juries. So to remind everybody, in 1983, in July, this is before the second round of the Sino-British discussions for the joint declaration, Deng Xiaoping's already announced that Hong Kong shall have the right to final adjudication. He also said that we can allow foreign judges when needed. Right? So this is something which was the Hong Kong legal profession being very proactive at that time. We had very proactive leaders, and for example, in 1983, the colonial government was bringing about an amendment in the Supreme Court ordinance because going to the Privy Council is not easy, right? Not easy to get leave, not easy to get certified. So they were trying to have a 5-member court of appeal, a full court, and so they proposed an amendment to the Supreme Court ordinance. Well, the Bar Association objected because we know we're discussing now about a new court of final appeal in the agreement. So let's not muddy the waters and have suddenly a larger court of appeal in Hong Kong. And then in July of 1984, John Swain, who was our first member silk who went into LegCo in Hong Kong, said in LegCo that after the resumption of sovereignty, Hong Kong should not only have the right to final adjudication, but also have judges coming to sit on our court of final appeal. Right? So that was important. And one must go back to see, well, why is it important? I mean, I've listened to what the previous speakers have said, but why is it important? I don't agree with respect that it's just a symbolic role for these judges to sit. I don't think it's a case, on the other hand, of us not having the right crop of judges or legal talent. We certainly have a very strong talent in our Court of Arms, in our local judges, in our substantive judges. Then what is the necessity? Well, the necessity is to define the character of the common law. The common law draws from a family of common law jurisprudence, right? We look at decisions from everywhere. We look at law reviews of different jurisdictions to look at our charter for human rights in Hong Kong is taken from the Canadian charter. So we have to take from that. That's when I remember meeting Professor Simon Young, who brought with him Canadian jurisprudence to Hong Kong, right? So Hong Kong is actually, I would say, a very blossoming member of the common law family, right? We have a Canadian charter. Britain doesn't have a charter, right? But on the other hand, we look at Britain as the authoritative sort of leader of the common law family. And you will see that in all major cases, in Ng Ka Ling, in Zhong Feng Yun, right of abode, who are giving judgments? Lord Justice Mason, the loudest judgment, right? In all important cases. And in 2020, Lord Reid was criticized for participating in a case that removed immunity from legislators, from prosecution, right? No doubt he discharged his agreement to the interpretation and the judgment of the court, right? There's no doubt about the integrity of that, but he was chastised in the British press, right? There was pressure on the British judiciary, okay? So, but the necessity is that it brings to this court an authoritative interpretation of important laws, right? The national security law will be interpreted by the CFA, and in accordance with practice, there will always be a non-permanent authoritative invited judge sitting to give judgment. That gives it the common law family flavor to the judgment. It becomes a judgment that really can show and exhibit, right? Not just fertilization, but a harvesting of judicial minds and scrutiny, right? Let me remind everybody that 90% of the laws in Hong Kong, especially the criminal law, is exactly as it is in England, right? The laws of the Public Order Ordinance, right, which is interpreted by our court, is also being interpreted by the British courts and looked at by the British Parliament because of the Extinction Rebellion demonstrations that we want to demonstrate outside West. No, it has to be Trafalgar Square. Bail is set very high for repeat offenders and all that, right? So Hong Kong wanted to follow the British example and plug in. The law is actually being used at the same time. I was in London at that time, Extinction Rebellion in 2019. Same problem faced by the British police, but not in such scale as is happening in Hong Kong. But why? This started not just with Lord Reid, David Perry, right? He was the prosecutor who is very respected by the Hong Kong legal community, has done a lot of criminal cases in Hong Kong, and he was asked to come up by the Hong Kong government, and he agreed, right, to prosecute the case under the Public Order Ordinance, right, which will come into interpretation. And his expertise, the bar allowed him to enter because he contributes his expertise, a substantive, it's not symbolic, to the interpretation. What is the British argument under the Public Order Ordinance? Right? And then this involves the Apple Daily case. And at that time, the Foreign Secretary, Mr. Raab, went on Sky TV to chastise David Perry for taking the case, calling him an unconscionable mercenary. I may be not quoting him exactly, but in that spirit, in those terms, forcing him not to take up the prosecution, which he has already taken up and which has applied his own professional standards and conscience, that it doesn't sit, inconsistent with his rules under the British bar to come and take up this prosecution on Hong Kong. And we have to admit him in the Supreme Court. He has been leading all the work. And the last minute, David Perry said, "You can't take it, you're being a mercenary." So he dropped out. It's not just Lord Reid, it's not just judges, it's also the British legal profession. Really? I mean, when have you ever seen a joint statement I don't mind personal resignation. The basic law provides for personal resignation, but this is deliberately an official resignation in official capacity as the president and deputy president of the British Supreme Court, in conjunction with the British government, with the foreign secretary and the deputy prime minister coming out in unison to say that we do not approve of the present administration and how it's changing life in Hong Kong. We don't approve. Since when does the British judiciary ever signify approval of what the executive branch of the government does, whether in England or in any other country? If you are so disapproving and it harms your reputation, how is Hong Kong worse off than, say, Brunei, the Sultanate of Brunei? What are these double standards? And my concern is the way it's done. If they resign personally, I will respect that, right? That it doesn't sit for whatever reason with my conscience. Fine, whether it's because of my loyalty to my sovereign and it's a, I have two audiences to feed and I'm feeling undermined, right? So fine. But when you do it in conjunction with the British government, right? And his words are, quote, I have concluded in agreement with the government. Since when has ever the British judiciary come out in a statement concerning international relations, right? And how they help out in Hong Kong with a joint statement? Astounding, right? And then the thing is the reason. Now, the reason is, quote, the judges of the Supreme Court cannot continue to sit in Hong Kong without appearing to endorse an administration which has departed from values of political freedom and freedom of expression, to which the justices of the Supreme Court are deeply committed. That's fine, you're committed to those values, but since when do you have the role of exercising your judicial work, whether in your domestic court or in foreign court, or your capacity as the Privy Council, to be affected by the executive branch, by the administration of that jurisdiction, to see whether your work will endorse that? Of course it won't. It's the independence of the judiciary.
Alan, could I ask you to wrap up?
I'm sorry. Yeah. And the third point is the purpose of this resignation is calling on all British judges to follow him, right? The situation is reached a tipping point where it is no longer tenable for British judges. It's calling for a boycott. It's calling for a boycott. And I'll wrap up by saying this. How does it? It's going to impact on Hong Kong, for sure, right? But why is there no procedural justice for the 7 million people of Hong Kong to have a say about this? And why is this part of the agenda of the British narrative of Hong Kong, which is Hong Kong is a lost cause? Might as well bring down the edifice. Sorry. For a practitioner, I very rarely go long on unpaid speeches. I'm very sorry.
Thank you. Thank you so much, Alan. Move to my colleagues. First is Professor PJ Yap. He's the director of CCPL. PJ, the floor is yours.
Thank you, Dean. It's an honor and privilege to be in the company of the two great sailors of Hong Kong and to be in the company of my learned colleagues. I just have 2 points to make today. Right? The first is I wanted to address the concern or the perception that the participation of the overseas MPJs harms China's overall national interest in Hong Kong, or that these overseas judges will pursue some independent policy in Hong Kong. Right? And I would like to debunk this myth or this perception. Right? The overseas MPJs have participated in about 700 cases since the handover. Of these 700 cases, the overseas MPJs have only dissented in 3 cases. 3, right? And no cases in the last 10 years. And let's look at these 3 cases. 2 are on the common law of torts, hardly an issue concerning national interest. And 1 is actually on interest payments, right? So these three cases where the overseas judges dissent from the CFA majority are hardly cases that impacts China's national interests. But some may say, even if they don't dissent, right, there might be a 3-2 divide in the CFA, and then you will have a foreign judge casting an overseas MPJs casting the tiebreaker. So let's look at that. As for such cases, the CFA has only split 3:2 4 times with the MPJ in the majority. So let's look at the 4 cases. The first case is on company law, not quite an issue concerning national security or national interest. The second case is on family law, but this family law is interesting. It's on whether it was against Hong Kong public policy to recognize a mainland divorce. And interestingly, it was the overseas MPJ who wrote the opinion, joined the opinion, saying that it's not against Hong Kong's public policy to recognize a mainland divorce, right? So here you have, right, an overseas MPJ ruling for the one country, right? The third case, I think most of us know, is Congo, right? The question was whether Hong Kong should follow the country's doctrine of absolute state immunity or retain the British colonial system of restricted immunity, which is where states have no immunity for commercial transactions. And in this case, right, the CFA held, the majority held, that this matter is an issue of foreign affairs, and there should be interpretation to the National People's Congress Standing Committee. But in their provisional view, they felt that Hong Kong has to follow absolute immunity, which is what the central government wants. Again, we see in this case there was no impact on national interest. Finally, the fourth case is on JR, and this is a really interesting case. But to be honest, I think both sides are actually tenable. The issue was whether a person who performs on a public road, right, a publicly accessible road, needs to get a license before they perform, right? The majority said no, the dissent said yes, right? And the issue hinged on the word admit, right? But you need a license if you're admitted, but does admitted require the presence of some physical structure or locality? Well, if it was a public road, which is here it was, and there was no barricades, no blockage, no cordon, no structure, then the CFA held that it was not an admission. Right? The overseas judge joined the majority opinion. But what's interesting was actually the majority opinion is actually more consistent with the Chinese text of the law. Right? There's some ambiguity in the word admit. Right? Does admit require a physical structure? But in Chinese, admit, the word used in the legislation was yap chong. Right? So it suggests there must be some structure, some chong to admit. So again, it would seem that the overseas judge in this case reached a reading that was more consistent with the Chinese law, which has equal binding force in Hong Kong. So altogether, 7 cases, which is only 1% of the CFA load, hardly a record of judges pursuing their independent agenda, hardly a record of judges, impacting national interest in Hong Kong. Right. My second point is this, as we know, and I think Mr. Dawes SC alluded to it, right, about the resignation of the judges. Certainly, I agree that it's a regrettable development, right? It's unfortunate for us in Hong Kong. But I would like to say one thing is I think we can be a little more understanding about the decision. And why do I say that? And the reason is this. Under the common law, there's a rule that on foreign affairs, the judges should speak with one voice with the judiciary. This common law rule was also enforced by the CFA in Congo, right? The fact is they felt that on a foreign affairs issue, the judiciary and the executive should speak with one voice. And I think all the patriots in the bar, all the patriots in the legislature, and all the patriots in executive would want the Hong Kong judges to speak with one voice with the central government on foreign affairs. So I think we should have some understanding if the British judiciary want to speak with the British executive with one voice on their own foreign affairs. Certainly it is a loss for us in Hong Kong, but I think we can accord a sense of understanding for the decision, even though we may not agree with it. With that, I thank you for your time.
Thank you, PJ. Thank you very much. I hope you can write it up and have a Hong Kong World Journal articles out of it. Thank you. Simon, it's time for you to make the final statement.
Okay, thank you very much, Dean. As the last speaker, I'll try not to repeat some of the very good points that have been made already. I'll just restrict myself to contributing a few new points. As we reflect upon these recent resignations and also reflect more broadly about the next 25 years of the HKSAR, I think it would be useful to put our system of overseas MPJs into perspective. And there are two aspects of perspective that I want to talk about. One is, of course, the perspective of the overall justice system in Hong Kong, the overall administration of justice. And two is a kind of temporal perspective, how we may have thought about our MPJs in one way back in 1997, 25 years on. I think we may need to think of them in a slightly different way. And in fact, you recall the former Chief Justice Andrew Lee, I think was quoted had made a statement as a result of these recent resignations, saying that the system of overseas judges might have to change or may not be the same as we go forwards. Let me come to the first perspective. This is situating the contributions of overseas MPJs in the broader justice system. Of course, as most of you know, they really contribute directly to the substantive appeals. But substantive appeals in the Court of Final Appeal are very few. And they do not, and some of you may not know this, but they do not have any contribution to the leave applications. In other words, they make no contribution to what the Court of Final Appeal actually hears. And now that all appeals that have to be granted leave before the Court of Final Appeal will hear it, that gatekeeping function is extremely important to the development of the law. And of course, our foreign judges or our MPJs overseas do not have any say in that at all. So that's one important point. And in fact, the number of leaves now that the court is getting, leave applications, is increasing. And I want to just give you some figures. In 2021, the total number of leave applications that were disposed of was 608. And the actual appeals, substantive appeals that were disposed of, was only 16. Right? So just looking at that from this perspective, the MPJs, assuming they're, I think they did contribute, I think they did sit on all of the substantive appeals, that's only 2.6% of all those cases. Now, when one takes it even further, let's look at this from the point of view of the entire administration of justice in Hong Kong, all cases, substantive cases at all levels of courts. I did a little bit of math this afternoon or this morning. And if you look at the cases in the CFA, the Court of Appeal, the CFI, District Court, Magistracy Court, ignoring taxation cases, etc., one gets something like 75,666 cases, and just in the year 2021. Right, and of course, if you take the number of substantive appeals in the Court of Final Appeal, of course, it's just a drop in a bucket, right? 0.02% of that number. So when one looks at it from that point of view, their actual sort of contribution to individual cases is quite minimal. Now, let me turn to the temporal perspective. Dean Fu, in his interesting introductory remarks, talked about two possible ways of thinking about our MPJs. They're either firewood, right, or they're the icing on I think he said a delicious cake, right? And I think one can think of them as both, if you look at it from a temporal perspective. I think the fire road analogy is probably accurate back in 1997, that they were quite needed to catalyze our system, because we were, frankly speaking, we were a blank canvas at that time, right? And the incoming MPJs had so much more experience, not just as judges, but as, apex court judges,
Yep.
And even as chief justices. So they had so much more to contribute to our system. 25 years on, I feel now they're more like icing on the cake. And let me just explain that with a little bit of data. Now, some of you may know, of course, that the number of foreign MPJs seems to be increasing, right? So when we started off in 1997, we had about 6 of them at the inception of the court. And then when Chief Justice Lee retired, he left the court with about 11 overseas MPJs. When Chief Justice Ma left the court, there were 15 overseas MPJs. And now, of course, we're down to 10, but nonetheless, as you may think, that because there's this increase in the number of MPJs, that maybe their influence and impact has increased. I tend to think differently. And the reason for that is, I think when you actually increase the number of overseas MPJs, and if you're trying to, ensure that all of them have an equal sort of amount of opportunity to contribute to the court, then each of their contribution gets spread thinly, right? And what you start to see is you don't see a lot of sustained impact by a small number of judges, which we did see under the Lee court. And I'll just give you some data here. For example, under the Lee court, I think many will know that the foreign MPJ that contributed most significantly was Sir Anthony Mason, where in the first 13 years of the court, he sat on 91 appeal cases, followed by Lord Millett, 50, and then by Lord Hoffman, 36. But Sir Anthony Mason really stood out in his contributions, and I think many of you will know he has contributed so much to the case law in constitutional law, criminal law, and many other areas, public law. So that we have not seen. And just to compare that with, say, the Ma Court, the 10.5 years of the Ma Court, what we started to see is a much sort of larger group of foreign MPJs who are coming for around between 18 to 25 appearances, right? So this is the group of Justice Gleeson, Lord Hoffman, Sir Anthony Mason, Lord Millett, Lord Neuberger, and Lord Walker, all hearing about 18 to 25 cases. So it's starting to spread a little bit more thinly. And I think the effect of that is you don't see this sort of contribution that gets developed over the cases, or over the case law, that this sort of concentrated contribution to the writing of the jurisprudence in a particular area. It's a way of where the judges really then are just seen as sort of visiting judges, making a contribution, rather than really taking ownership in the jurisprudence. Right? Certainly with the permanent judges, they have taken ownership of the case. So they are responsible for the development of the law in certain areas, and they see the direction. They can tell you where the direction of the case is going. But when you have judges sort of coming in and sitting on a case here and there, and their opportunity to contribute is much less, then I think their overall contribution becomes reduced. Another important statistic is the writing of majority judgments. In a very interesting article by Stuart Hargraves, an academic at Chinese University, published in the Asia Journal of Comparative Law, he makes the important observation that the foreign judges seem to be writing less majority judgments, and I think that's right. And then he goes on and he finds that, in fact, they seem to be writing less of the more politically sensitive judgments in public law, human rights, etc. He goes on and draws an inference and says that may be by design, that the court is sort of insulating them so that they don't come under criticism. But we can debate whether that's a fair inference. But nevertheless, it does seem like they are writing less of the majority judgments. And I think that's probably right. And that, in fact, it is the permanent judges who are actually contributing the most to the main judgments now. And when one thinks about that now 25 years on, it just reflects how much more experience the permanent judges have acquired. And I think the court has been quite clever and strategic in how they have tried to ensure that there is continuity of experience. Yes, we now have two fairly recent new appointments, but we still, of course, have two very experienced judges to allow for that continuity. And so, at some point, we may need to debate whether we should have a fourth permanent judge. Of course, if you have a fourth permanent judge, that would mean there would be less opportunity for MPJs to sit. But I think if we were to have a fourth permanent judge, we would do just fine. I think we certainly have the expertise and the and the talent to fill that fourth permanent spot. But I still think, as the Dean suggests, that the MPJs can be seen as icing, and they still have quite a bit to contribute, so long as they are of the caliber that we've had in the past. And so I've said in a media interview, we shouldn't just appoint foreign judges for the sake of appointing. I think we should do so only because if they can really contribute something special, as the pre-existing or the former MPJs have contributed in the past. So I'll stop there. Thank you.
Okay, thank you, Simon, very much for all the information and the comments. So may I ask whether the chairman of the bar have anything to add after
perhaps,
all the speeches and the comments made?
No, thank you very much for all the observations. It is an interesting panel that you have picked. I noticed we all approach the issue slightly differently. We address slightly different questions. Alan gave us very good historic background that took place when some of us were still a kid. Thank you, Alan. And of course, your colleagues approached the matter in a more scholarly manner, I must say. But just a few points on a more practical level. Simon made some very valid point about numbers. And I think we can, of course, analyze the matter by looking at the numbers. But I think we can't really just approach the matter by looking at the numbers in many different sense. For example, yes, insofar as the spread is concerned, in the early days, Sir Anthony Mason, Lord Millett, they were here for longer period. They were involved in more judgment, and you see more of the fingerprints, and that must be right. And of course, I think even Chief Justice Lee said on a number of occasions, especially when I think we had in one of the bar mess, I remember, that he publicly thanked Sir Anthony because of his contribution, especially in the early days when our constitutional framework was developing. His experience as Chief Justice in another jurisdiction was hugely valuable to Hong Kong. Now, we then move on to Chief Justice Ma's era, where we had more foreign MPJs. It was a good thing. We had more expertise. There were a few more Australian judges here. And we were able to interact with more judges. Now, numbers is one thing. One of the other experience, which I'm sure Alan would agree, and as he has got more experience than me, he's a senior man on this panel. When you appear before a foreign MPJ in the Court of Final Appeal, that means the collective experience of the inner bar is that, wow, I mean, these are really top jurists. The sort of questions they ask are penetrating, and they can share with them, not only in the written judgment, also in the discussions at the hearing. And I would presume when judges are deliberating, their experience. Yes, sometimes you may not be able to see their fingerprint expressly, especially when we are dealing with an area where the court like to use joint judgment. So the judgment is in the name of all the judges. You can't see who contributed which part. But if you have sat in court hearing the arguments, you will definitely be able to see their contribution. I don't think there's any contradiction between what I've said and what Simon has said. It is just two different ways of looking at their contribution. I think we all agree that they played an important role. It is difficult to quantify it. I mean, that is all I wish to add at this stage.
Thank you. They're talking about the soft power of foreign judges, the invisible influences throughout the process. So we do benefit from that. We invite them over to give talks to our students, so create a different sort of impact, of course. Alan, do you have anything to add?
Thank you, Dean. I don't quite share Simon's view that the utility of foreign judges in Hong Kong is reducing and the need is less. As I said, part of their role is substantive. You know, they do, as Victor just said, really, wow, it's like appearing before the Privy Council. And not just from Britain, you have the top people from Canada, from Australia. Where else in the world do you have such a common law forum that you can address, right? But the other aspect is that it does have a symbolic role, because when people look at the final court of Hong Kong, the judiciary system, the rule of law in Hong Kong, they see that their own judges sit and participate in that court. And these judges will not stand for nonsense. Any hint of interference will be amplified, right, and broadcasted. So this is a great shot of confidence for Hong Kong being an international financial center, and hopefully in time to come, being the real center of the Greater Bay Area. Right? So you really need to know the role that they play, because it's like scrutiny by participation. The other matter is this: it is clear that there is nothing wrong with how the judiciary is operating in Hong Kong. Right? It's amplified by Lord Justice Reed, Lord President Reed, that it's 100%, 100 marks, right? No interference, right? All cases come up to here. I don't think they should be looked at in Simon's way of, well, maybe leave is restricting. Well, this is the apex court. In any jurisdiction, the apex court will have a leave mechanism, all right? We can argue about whether that leave should be uniform and calibrated. But the point is that the necessity is there, especially at this time. Especially at this time, I would like to see judges like of the caliber of Neuberger and Mason, right, to sit on cases on national security, right? Let the whole world see. Why do you not want to accept that challenge, right? But instead to write Hong Kong off, to bring the edifice down. And this is my great concern for the people of Hong Kong, is for them to say that this is a lost cause, right? That we cannot participate in this anymore. And therefore, my view is that this boycott cannot be allowed to succeed. It's not a lost cause. People like Lord Justice Sumption is quite right. This is an invasion on judicial integrity and an invasion in David Parrott's case on professional integrity. It not only affects Hong Kong, it affects Britain as well. It is the head of the common law family. So I think we still have to continue this fight. Thank you, Dean.
Thank you. Simon, you want to make a brief response?
As I said, I was trying to just contribute some new points, not to suggest, of course, that I don't think there's any benefit that the foreign judges bring. In fact, I think one of the greatest benefits that they bring is some diversity to the court. And in fact, when you go and look at the history of the debates about the establishment of the Court of Final Appeal and LegCo, there was this concern that many had expressed, that they feared that the Court of Final Appeal would be another Court of Appeal. And so this having the foreign judges system is a way to not have that. I don't necessarily agree that a Court of Final Appeal, even if we don't have foreign judges, would necessarily be another Court of Appeal. I think just the structure of it, having another tier of court where you have more an opportunity to look at the cases more closely. That in itself will differentiate a Court of Final Appeal from the Court of Appeal. But nevertheless, having the foreign judges certainly brings diversity, which I think can contribute to better decision making.
Thank you. May I invite the audience to input your questions into the Q&A box if you have any question. So could I ask Anna to reflect or respond?
Great, thank you, Hualing. I thought I would just clarify something raised by, I think, Mr. Hu SC. And since he's not here to defend himself, just to say, to give another of Lord Reid's reasons. So he was very adamant in his evidence before the House of Lords Committee that this was not, his decision was not the result of political interference or executive control or anything like that. And he pointed to the fact that the participation of the two serving UK SC judges in Hong Kong is a result of an agreement that's actually been made between the Lord Chancellor and the Foreign Secretary and the court, so that their involvement was had to be considered in a way that I don't think, if there was a similar kind of executive involvement or pressure on a retired judge, I think would be quite different. And I think so the executive does have an interest in its own courts and maintaining those. And I think that's not quite so unusual. So in Australia, in some states, I think in Queensland, if you're a serving judge and you're invited to sit overseas on another court for a little while, you need permission from your head of jurisdiction, but you also need to get some sort of approval from somebody in the executive because it affects the working of the court. So there is those kinds of arrangements. And I think in Australia and hopefully in the UK, the executive is very careful not to infringe on judicial independence. But that I think is just another aspect of, when you're drawing your judges from elsewhere, you have to think about all these little things that wouldn't come up necessarily if you rely on judges solely from the jurisdiction that you're in. And of course, there are some examples of governments that could do worse, right? That they could seek to control what judges do overseas in a lot more harsh ways. Travel bans, sanctions, law society complaints and those kinds of things. That's very rare, but it's a possibility, and we haven't seen that happen. So I just wanted to kind of clarify that the sense that this was a result of political interference, I think, has been resisted by Lord Reid himself.
Thank you, Anna.
Can I just
Sure.
follow up very quickly from what Anna just said, because it reminded me of something which I meant to say, which is that precisely because this is an arrangement, it is first, it's a diplomatic arrangement between, of course, the Chinese government has to give its consent for Andrew Lee as the first Chief Justice to speak to the Lord Chancellor and say, can we have it's a formal arrangement, yes. And precisely because it is a formal arrangement, it's a breach of the joint declaration, right? I mean, this is a promise to the people of Hong Kong, right? And this is not how we understood it, right? And so therefore, thank you for bringing that up. That's all I wish to add.
Thank you.
No,
DJ, you
really
have the final word.
Thank you. I would just like to make one point, which is, so as I say, if we look at the data, right, the overseas MPJs do not disagree with the local judges much. It's less than 1% of the caseload. So what is their function? And I would like to defend their function. And I think their relevance is very important. Their functions are twofold. The first is that with such eminent jurists from such respected jurisdictions sitting in Hong Kong, they will enrich the judicial deliberations behind the scenes, so that the decisions and judgment written in the end will be able to stand up to greater scrutiny. Number two, and I think this is also very important, is when you have eminent jurists sitting in Hong Kong and they join in the opinion of the local judges, it legitimizes the judgments. It shows the world that it stands up to international scrutiny, right? It observes international rule of law. So I think the choice of the jurist sitting on the MPJ, as also MPJ, is very important for this signaling, this legitimating function. Thank you.
Thank you. Now we are receiving some questions. One is a matter of fact. I think the one question basically says, what's the impact in Hong Kong society, how people perceive the resignation? And probably is Alan and Victor probably know better within the legal community how that has been perceived and what is the sort of the ripple effect of the resignation.
Dean, are you asking me to respond to that?
Yeah, sure. Yeah.
Yeah. I think that it obviously it depends on whether you're speaking to the informed part of Hong Kong society or the man in the street who's not very tuned in to the subject. But for the legal community, it was certainly shocking. It was shocking because it's you must remember, this is not just in the last 20 years that they come and sit. Right, we've been in the British common law family for 155 years before that. Right, I mean, I belong to that generation where I have to go to England to become a barrister. There wasn't a law school until 1973's graduate for the first time. Right, so the umbilical cord is very strong, and the effect felt is tremendous because. When I appeared in the Singapore court once. I'm also admitted in Singapore, and you find that although it's a very able court, it's a different part of the common law family. But when you stand before the Privy Council, right, it's like it's the apex. All the judgments in the common law jurisdictions are looked at and analysed if relevant. Right, it is really the fountain, and for immediately the how would the common law the man in the street see this? It's an attack on Hong Kong. It's basically bringing the edifice down. Obviously, what is a very good arrangement. There's no doubt that without people like Mason and Hoffman and Millett sitting there, the CFA will not have the luster. Right? However competent and good, it will not have the luster and respect from the common law world. So that I think is the impact. Thank you, Dean.
Yeah, can I just supplement? As I have said to the public, we actually got wind of the fact that there's a possibility of this happening about 2 to 3 weeks before the resignation. So quite a bit of work was done behind the scene by many actually. And we have got friends in London, a lot of British people who have worked and lived here, the business community, in fact, even some politicians who have Hong Kong background. I believe they're probably in the minority, but they were all, when they heard this, a lot of people were actually trying to help Hong Kong. So there were 2 weeks where there were uncertainty. The views of the British business interests in Hong Kong was, of course, that they wanted to keep the system. Now, the timing in which it happened was not very satisfactory, because you remember that on the same morning, there was supposed to be a Westminster Hall debate on the role of British judges sitting overseas, and they pulled the trigger just before the talk. So there I was. I had my headphone on. I was going out and for a walk, and I was going to listen to it as I was walking in the park, and then to be informed that they actually resigned before the Westminster Hall debate. So they preempted the debate. And it is one of those issues that I must say where the vast majority of the legal profession, the bar, the solicitor profession, I think everybody was speaking with one voice. We find that regrettable. We wanted the system to continue, and we were working very hard to urge the remaining MPJs to stay. And we of course thank them for making the decision at the end of the day.
Simon, there's a question for you to clarify. When we said that the MPJ brings diversity to Hong Kong, I mean, how that happened? Could you say a few words on that? And for PJ, the question is, can you elaborate a little bit about the speaking in one voice on foreign affairs, then how that would work, that type of a commitment? Can you just elaborate on that idea?
So, Dean, just briefly, and speaking more generally, I would say diversity in two senses: diversity in thinking or modes of thinking. Whether it's because of their training in their respective legal system. I think it's more, the significance is more in that they wouldn't have maybe the orthodoxy of thinking about Hong Kong law. That they can bring a fresh perspective, and they wouldn't feel sort of constrained by certain norms that that we followed here and that have gone unchallenged. And then, of course, there's just diversity in background. Whether we're talking about gender, whether we're talking about urban, rural, growing up on a farm, and just differences in age, of course, experience. So, all kinds of diversity in that sense.
PJ?
Thank you, Dean. I'll just reply as follows. When I talk about the one voice principle, I would generally say that it would largely apply only to the existing incumbent judges, right? So if you are currently a member of the UK Supreme Court, it's very understandable if you want to speak with one voice with the executive government. But when these judges retire from the bench, from the UK judiciary, I think they are free to sit in the individual capacity in Hong Kong. So I think this tradition can still continue, and there's no violation of the one voice principle. Many of the Australian and Canadian judges all sit in Hong Kong after they retire. So I think this approach can be pursued and should be pursued. But can I go and answer some questions on Singapore?
Sure. Yeah.
Since I guess I'm the only Singaporean on this panel, and there's been questions about
I should have brought that up.
Whether Singapore judges should sit on as overseas MPJ, right? Again, I'll like to focus on the facts, right? According to the leading rule of law index by World Justice Index, global ranking of rule of law, right? This is probably the leading index in the world, right? In 2021, let's look at statistics, right? Hong Kong is still doing very well. It's ranked 19th, right? Still doing very well, notwithstanding the NSL, notwithstanding the electoral overhaul, right? It's 19. The United States is 27, right, which is below Hong Kong. The UK is 16. Australia is 13. Canada is 12. New Zealand is 7. Singapore is 17. So Singapore is still ahead of Hong Kong. So clearly Singapore is, right, according to the world, right, the perception that the rule of law in Singapore is still very strong. So that, I think that's fact number one. But we also have to look at fact number two. Fact number two is the Singapore Court of Appeal, the highest court, has never struck down a single legislation in the country's history, right? Nothing has ever been a violation of constitutional rights in Singapore. I mean, according to the highest court. So this is fact number two. As I mentioned, right, that, when you appoint new MPJs, you're sending a signal. For some, both factors I mentioned will be a plus. For others, it may not be so. So again, I think I'll have to leave it to the government and judiciary to decide what signals they do want to send with their appointments.
Thank you. Alan, your suggestion that foreign judges should participate in national security cases has provoked quite a few questions. I guess one is a matter of facts. Are there any foreign judges participating in sort of national security cases elsewhere? How do you sort of reconcile the Chinese government concern of the security and we'll talk about the reputation, right? The foreign judges coming to Hong Kong, if they are on contract towards family law, probably government may have more confidence, will be easier to accept. But then if the recommendation is to move them into the more sensitive areas, then probably would make things more difficult.
First thing I have to say is that the foreign judges to come and sit in Hong Kong are invited to come to Hong Kong not as window dressing. They're invited for a leading role in many occasions, right, to bring their experience and jurisprudence to bear. And so on that basis, it's very clear in my work with the Chinese government, because I am a member of the Law and Social Committee of the CPCC. So I meet a lot of the Chinese people concerned with how they look at Hong Kong. The thing that as far as Beijing is concerned, they are quite happy that the laws that are passed, whether by them directly, right, whether adopted under Annex 3 or whether under Article 23 by Hong Kong locally, will receive a baptism by fire in terms of judicial interpretation powers finally in the CFA. All right, that there's no caveat that these cases go to a special list of cases in the CFA. All right, these cases will be, and these are the very cases that the foreign judges, especially English judges, are very needed, because, as I've said, a lot of the cases now, because a lot of the cases now are under the Public Order Ordinance, rioting, illegal assembly and all that, and this is, as I said, directly taken from British jurisprudence. We're following Britain in every aspect. Look at what's happening, as I say, to the Extinction Rebellion cases. So I think that as far as the Chinese are concerned, they're happy for there to be that true integrity of judicial interpretation in the hands of people like Mason, Neuberger, and Reed and Hoffman. And if not, as I said, they never need to give it to us in 1984, right? It was really in very good faith, in extremely good faith. And I think that the fact that, I wish to add this, that the Chinese government is not making advantage of this situation by saying, oh, well, double standards, right? You want to shut the door on us, then so be it, right? No, right? They haven't in any way expressed the view that fine, we will no longer, I will shut the door on you as well. So I think that it's important to remember that Beijing does recognize the character of the common law in Hong Kong, actually knows it very well. And I think that they are really waiting to see how we in Hong Kong will react to this impact. And I think that especially for the international narrative, this subject is not going to go away, right? Because when you talk about the Greater Bay Area, we're talking about maybe a Greater Bay Area court, right? A commercial court, right? We're looking at something, a bigger development. This is more than a spanner in the works, right? So Dean, thank you for letting me answer that question.
Thank you. Thank you. You brought this idea to me to have this roundtable. So thank you very much. So there are quite a few questions on the option of Singaporean, Malaysian, Indian judges. So I guess the pointed question for Victor is, how strongly you would recommend judges from those sort of non-traditional jurisdictions.
Can I just make it clear that I'm not advocating that, in the sense that there's a reason as to why for the past 25 years our MPJs are from the UK, Canada, and Australia. There's just a bigger pool because of the common law tradition, because of the existence of the top jurists in those jurisdictions that are internationally renowned. We are where we are. This suggestion that we get somebody from Singapore and other jurisdiction actually came from somebody other than the 8 of us. And in responding to that, I must make it very clear that I think the official position is that we are after top jurists. So we are not in any way trying to discriminate the other common law jurisdiction or trying to belittle their contribution to the common law world. That's the first point. Now, I then see a number of questions on how does one expect Hong Kong to invite judges from those jurisdictions, given their political situation, given the point mentioned about on foreign affairs, you're expected to speak with one voice. Now, we must also remember that the courts, they do not rule on foreign policy. The policy issues are on, especially in a court in Hong Kong, because foreign affairs are a matter for the central government. So that is why what happened in Congo happened. That is why there is the referral. Now, Paul Jen raised another interesting point, but that is, of course, one of a basket of factors that one has to challenge. In considering which jurisdiction we should go to, we are, of course, we need to have an eye on the situation there and the characteristic of the particular jurisdiction, not just whether they are common law jurisdiction. Of course, we mention those countries because we really have to go to somewhere with a common law tradition. But I must say that we must keep, of course, our eyes open as to possibilities. But I think the past 25 years has demonstrated that there is a good reason as to why our judges are from the few jurisdictions that we are more accustomed to.
Can I follow up to what Victor just said? Judges' contribution to jurisprudence in Hong Kong and anywhere else in the common law world, especially senior judges, is not just in interpreting cases. A lot of them contribute to law reform. So that, like the Law Reform Commission, all the subcommittees are always chaired by sitting judges, right? And sometimes retired judges. And the point is very simple. It's not discriminating against any other jurisdiction. It's really the other way around. It's the relevance and application. For example, Simon and I sit on the Law Reform Commission on police powers. Where's the relevant jurisdiction? Well, New Zealand, right? Australia, right? Canada, UK, but not quite so Singapore because of the internal security legislation there, right? Very, very different scheme of things, right? In India as well, right? So you look at comparable jurisdiction that's relevant to Hong Kong, right? And as I've said, Canada, because we have our Bill of Rights Charter modeled on them, right? And as Simon will agree, that we took a lot from the New Zealand Police Powers Code when we sat on the Law Reform Commission to make recommendations as to which jurisdictions to follow. So it's really shaping the development of our own common law jurisprudence by means of interpretation and in law reform. Thanks.
So Anna, I have a question for you. Actually, it's like how unique the Hong Kong existing system is comparatively. I mean, do we see the other countries have a similar system?
It's a really good question, because I think in Hong Kong sometimes it's assumed that it's very unique and happens nowhere else in the world, but that's not the case. I think what is unique about Hong Kong is the fact that there is only ever one foreign judge ever sitting on a panel of the CFA, and the institutionalization of that tradition, if you like. I mean, I know that there have been a few cases where there hasn't been one, but generally it's just one. In other parts of the world, it's much more flexible. So you might even get a majority, even all of the judges sitting on your apex court as foreign judges, whether they're from one jurisdiction or several different ones. So I think in Hong Kong, that's a really interesting point of distinction between how the Hong Kong system works and other countries, say in the Pacific, in Africa, and in Europe that use foreign judges. And I think that, again, picking up on what Simon was saying, it kind of tempers and means that the influence of that foreign judge is quite different, and may also allay some of the concerns about sovereignty and all of those issues that sometimes arise that you might get, say, if there was a panel of all overseas judges. I think one question that sometimes comes up, and I think it's kind of hinted at in the Q&A, is whether other countries restrict the kinds of matters that foreign judges can hear. That's less common, but also not unusual. So in some cases, there's either a rule or a kind of more often a tradition that foreign judges won't hear particular kinds of cases, whether that's because of expertise. So just say the case involves Indigenous customary law or something that a foreign judge really would not have much knowledge of, or sometimes it's framed around sovereignty issues. So sometimes foreign judges won't sit on constitutional cases for that reason.
Death penalty cases.
Yeah. But there is a question too about other countries where foreign judges do sit on national security cases, and that is reasonably common. So in Fiji, there was a coup leader, the 2000 coup. He was charged with and tried for treason, so kind of the biggest national security offence you can have, and that was before a foreign judge, an Australian judge. And I think in that case, there was a sense that the judge was an outsider. Maybe some of the local judges didn't want to hear this case, given about how divisive it had been in the community. And so they turned to a foreign judge to hear that kind of case. And I think similar issues were at play in cases concerning civil unrest in Solomon Islands after the upset, civil unrest in the 2000s. So again, there are aspects. Of course, Hong Kong is different. It's its own unique context, but there are comparable situations in other parts of the world that might help Hong Kongers and international observers like myself to understand a little bit better what the possibilities are. Just on the diversity of the court, which nationalities are drawn. It's interesting globally that the US is not very much represented as in the cohort of foreign judges in the common law world. United States judges tend not to travel abroad and sit. Partly, I think, because their retirement age, they don't have one, so they're appointed for longer terms. So your pool is a little bit different. But maybe some of the senses of sovereignty that you see in the US, the US would never accept a foreign judge on its Supreme Court. So maybe they feel that they shouldn't be sitting overseas. But some countries, there are judges. Singapore, India, Malaysia are all represented on the Apex Court of Fiji currently, and Sri Lanka as well on that court, as well as Australia and UK. When I say represented, judges from those jurisdictions sit on those courts. They're all retired judges or judges serving in their individual capacity. So there are possibilities, but I do agree with what's been said about what signal that choice can send, and also the importance of expertise. So judges, like any of us, are all informed by our legal tradition and the way we've learned law. So you can see Australian judges bringing a particular attitude to interpretation of the law. You'll see UK judges maybe bring something slightly different that might complement, and Hong Kong can get the best of both in that sense.
Can I ask a question for Anna? I mean, the jurisdiction that you have mentioned, they tend to be really smaller countries with a lesser pool of talent and a smaller professional pool of judges. And of course, a lot of them with a colonial history. All these factors combined and created a situation where their apex court are staffed by foreign judges. Looking at the situation here, if there comes a sad day where foreign judges are no longer prepared to sit in Hong Kong for whatever reason, I mean, my view is we are not in a situation where we can't cope. I think others would also agree with that. I mean, Hong Kong is sufficiently large and the profession is sufficiently large for us to have a number of top talents. And so that situation will probably not arise in Hong Kong.
Yeah, I agree 100%. So the reason for the presence of foreign judges is not in Hong Kong is very different to that in some of these small Pacific Island states. That said, it's not the only country, I think, that does this. So Papua New Guinea is quite a large country. It's had its own judges since the early 1980s. It could probably get by with no foreign judges as well, but they continue to draw on foreign judges. And I think for similar reasons that Hong Kong does, they want the expertise, they want the common law, they want the commercial law expertise that judges in Australia and New Zealand have had exposure to. And maybe it's that sense of, you know, being part of the common law world and the prestige that comes with that. So again, Hong Kong is different, but also there are other countries that are similar. And I think the other one is some of the smaller, very small European states, you know, Liechtenstein, those kind of places, which are economic centres, right? A bit like Hong Kong. And they they still use foreign judges as well. So you can see some parallels that, that aren't complete, but are kind of interesting nonetheless.
Thank you. There are a few other specific questions, such as why not Irish judges? And anyone has answer to it? Probably it's just history.
It's a good question. Why not? It's possible, and it could be. I think Ireland's a little bit like the US in that it is a little bit represented in the foreign judging world, but not much. I wonder. I mean, no, I'm not going to speculate. Yeah.
But as I said, if I can add on this, that it really is the jurisprudence, how those jurisprudence will be relevant. Obviously, cases in the Cayman Islands or British Virgin Islands or the Pacific Islands is not going to of any influence or impact for the cases we see in Hong Kong, right? And also, as I keep saying, that Hong Kong's the laws in Hong Kong, whether it be common law or statute, are largely, especially in the criminal cases, are largely grafted from England. So it's a very authoritative interpretation. Right? So therefore, it's relevant and it's effective. And when you talk about national security legislation, well, I mean, who else do you want to sit on this, right? You don't have that legislation in England, but yet you still have like the public order ordinance, right? These principles certainly will cross-fertilize, whether the national security or public order, right? Just of the same character, right? So I think that I see the necessity as very, very potent. There is a need, precisely because this is a time where people have no confidence, can I use the word, in the national security legislation that's enacted by Beijing for us, right? And also the coming local legislation under Article 23. There's still other matters. But on these things, as I said, this is not unique to Hong Kong. Every country has national security legislation. And it is good for Hong Kong to see, well, if you don't like Hong Kong, how about those in the UK, right? In America, right? They have autonomous regions like Puerto Rico, right? Look at the Northern Ireland examples. You can see all these cases, they are relevant. Right? And this is where I say the need is actually here, but they are pulling the plug. It's also the timing, right? It's like Hong Kong's going to be torpedoed in this. I'm sorry to be so gloomy, but then, yeah, it's affecting me. I'm sorry. Thank you.
Probably a couple more questions before we wrap it up. One is how possible it is in Hong Kong to have judges from law schools. Is that something worth considering in Hong Kong, given it is happening elsewhere? Simon, you want to
well,
answer the question?
Hong Kong is a fairly small jurisdiction, and I mean, these things don't sort of change overnight. We have a process by which we have the recommendation committee, and the chief executive makes the appointment, and the recommendation committee, of course, is chaired by the chief justice. So I think there are certain traditions, that are quite strong, and I think they will probably continue, but that's change probably will happen, but more slowly. I would just note that some of our best judges in Hong Kong were academics in the past, so something to keep in mind.
Yes, in fact,
from Hong Kong University.
In fact, I think it is probably fair to say, from the perspective of the bar, you look at the contribution of somebody like Mr. Justice Ribeiro, to our jurisprudence. And Hong Kong, you can proudly say he taught at the faculty.
Yes, we are very proud of him. So finally, probably just I just go around the sort of panel to ask this question. So now Alan is very much depressed. Normally you are not depressed. Normally you are very hopeful. What we should do, right? Can I just start with PJ, and we reverse the order, and we wrap it up.
Thanks, Dean. I don't think it's very dire yet, because the fact is, I understand that the rest of the overseas MPJs have agreed to continue to stay. So unless they too decide to resign in the coming years, I think Hong Kong can proceed with what it is doing. Perhaps one can expand the recruitment from New Zealand or Canada. Right? These are jurisdictions from which Hong Kong has already been taking judges in the past or have taken judges. So if the UK judges are not so keen on sitting, there's no harm, or in fact, it will be beneficial to expand the MPJ slot from Australia, New Zealand, and Canada.
Thank you. Simon?
That's right. The way we recruit overseas MPJs is different, of course, from how we recruit any other judge in Hong Kong, even though the appointment process may be the same. And I think it's very much an organic process. I mean, it's not by open invitation applications, right? It's very organic. And it's very path dependent. I mean, things that have happened in the past, I think, will very much determine how things will evolve in the future. And so these recent 2 resignations are quite significant because that arrangement, having the 2 serving justices from the UK Supreme Court, was already supplied. It was quite a certain arrangement that we would get these 2 judges. Now we don't. Now we have to rely on the more uncertain organic process, but it's a very effective process, and of course it all revolves around the Chief Justice, but particularly are both existing overseas MPJs and former MPJs by word of mouth, and it's very powerful. And so I'm very confident we will continue to see this system thrive, and I'll just stop there.
Anna.
I think I've got to agree with PJ and Simon on the fact that I think the use of foreign judges looks like it will continue as an institution. I was really struck listening to Alan, actually, Mr. Hu SC, and his view that the UK judges can make a decision based on what they think is in the interests of the UK Supreme Court, but Hong Kong has a stake in this as well. And I think that is a really important dimension of foreign judging to note. I framed it as having 2 constituencies, right, that don't always necessarily talk to each other. Of course, they do in some ways, but in other ways, sometimes one can become more important, or one can take all of the attention over the other. So I think that part of the continued success of foreign judges in Hong Kong will be communicating between those 2, making sure that people understand what Hong Kongers want and need, and at the same time understanding these different pressures that foreign judges are under as well. It's such a unique kind of position for a judge to be in. It's not an easy one, and I think that could help.
Alan, I also added to the question is, should we have the MPJ foreign judges after 2047?
Oh, that's a big one. I let me say on the record, I don't buy into 2047 as an expiry date, but that's for another time.
Another conference, right? Sure.
What I would like to bring out now is the role of the Hong Kong government in this, right? It's not as if there's nothing to do in England as far as the government is concerned, because there's a 6-monthly report on Hong Kong. And where does this report come from? It comes from the ground in Hong Kong, from the British Council, British Consulate here, British Chamber of Commerce, a collection of views, goes up to the forum every 6 months, right? And the writing's on the wall. I mean, I had a heads up before Victor. I knew about this months ago. And I had arranged with two prominent members of the legal profession. One is Peter Thompson, who's a leading partner of Johnson Stokes, and Martin Rogers, who ex-Clifford Chance, were now head of Davis Polk. And the three of us, had a Zoom meeting with the Labour Party representative that is got the Hong Kong portfolio on this subject. And the arguments I put to him by Mr. Rogers as a British national, by Mr. Thompson, and he's a great Labour Party supporter, convinced the chap. And we had a 2-hour conversation, and then nothing. Shut down, never came back. And then I read for Lord Falconer of the Labour Party. This is a political situation. What the two judges have done is to make a political statement. It's not about saying, oh, there's not enough business in Hong Kong, or I'm not feeling too well, I want to resign. No, it's deliberately in conjunction and in step and in collusion with the British government to make a political statement, which is to boycott the CFA in Hong Kong. It's a call to the common law world. Shame, shame. And this should not be allowed to continue. And the way to do it is to engage them in the common law way, which is what? To come and speak, ask for procedural justice, to go and speak on the Foreign Affairs Committee, and report every 6 months. Just go up to the Foreign Affairs Committee, put your name down, right? There's so much interest in it now, right? Go to the ETO in Hong Kong and say, look, what are you doing with the... I mean, you're supposed to be Hong Kong government's voice. The Hong Kong government should help NGOs in Hong Kong to shape the international narrative. It's not just about the CFA. It's like Hong Kong is burning. It's lost, right? It's all part of the whole anti-China agenda narrative. It's lumped in with Xinjiang. It's lumped in with Taiwan. It is we don't want to hear it. We have to stand in unison. It's a political a confrontation. And therefore, the way to do it, I think, is don't give up the fight. Engage it. If there's international attention, then let that attention bring the discussion forward, right? Use democratic procedures to try and bring the point across. I think this is just a battle in the war for Hong Kong, right? There's still Article 23 to come, right? There will be maybe a criticism of Hong Kong's electoral development, right? With the chief executive elections coming up, you see. So it's not, the whole situation is dynamic, it's still continuing, right? So therefore, I think that it's time that, I thank you, Dean, for us to have this opportunity. I think it's time at least for us in Hong Kong to discuss this, not just amongst ourselves, so as to inform Hong Kong society, but also to have a discourse with the international community. At least listen to the people who are living in this system with what you are doing to us. Thank you, Dean.
Thank you. Finally, Victor.
Yeah, can I just make 2 points to wrap up? The decision to resign, obviously the decisions made by the two Supreme Court justices. There are many stakeholders, of course, affected by this decision. I mean, of course, we've said politics must have some part to play in it. They have in their statement referred to the fact that they have considered British national interests. But there is one important stakeholder, one group of very important stakeholder, and very little mention have been made of their interests. That is the people of Hong Kong, our court users, the people that our CFA is supposed to serve. How about their interests? how are their interests affected by this decision? Can I call upon everyone to think about this? Secondly, there is actually a question about this. There's a question about the perception to the business community. It is said that this is affecting decisions of businesses. Perception is important. And this, together with issues such as the national security law, is hurting Hong Kong's business interests. Now, I actually don't think the resignation of the two sitting Supreme Court justices will have much impact, especially given the others have decided to remain. This is a place where, because of the unique structure, the infrastructure in Hong Kong, there are thriving business opportunities. I mean, there are other challenges. For example, you recall a few months ago, there were a lot of discussions on anti-sanction law. And I mean, those are really topics that would have a serious ramification for example, the financial industry. But insofar as the resignation is concerned, I personally can't see really that much effect on Hong Kong as an IFC or foreign business interest here. I mean, what everybody seems to be more worried about is our COVID policy that is driving a lot of expats away. I see everyone nodding. So I hope there will be development on that front. That is, of course, not our department, but I hope things will be very different in a few months' time.
So on that note, I want to thank everyone for sharing your insight. It's a fascinating, very exciting discussion. And I hope we could have a seminar, forums, workshops to talk about other things which are important for Hong Kong. And finally, I want to thank all the audience. As I said at the beginning, we will have more face-to-face meetings. I wait to welcome to the campus. So thank you so much. Thank you. Thank you, everyone.
Thank you.
Thank you very much.